Court rise.
Sherman McNicholls versus Judicial and Legal Service Commission.
Bill, I'll just give us a moment to sort out our bundles, which come down all tied up indeed. Yes.
My Lady, in this appeal from the decision of the Court of Appeal of Trinidad and Tobago, the 25th of July of last year, I appear with my learned friends Mr. Benjamin and Mr. Jones for the Appellant Chief Magistrate and the respondent, the Judicial and Legal Services Commission of Trinidad and Tobago, represented by my learned friend Mr. Knox. The Commission is a body which is constituted under Section 110 of the Constitution of the Islands, and for this purpose has power to exercise disciplinary control over judicial officers, of which the appellant, the Chief Magistrate, is one, having held that office since 1999. The litigation is another chapter in a prolonged saga which has bedeviled the political and legal life of Trinidad and Tobago, and which has already come to the attention of the board in various guises on a number of occasions, and my Lady Baroness Hale and my Lord Mance will be familiar with at least one of those appeals. They arise in broad terms out of allegations made by the Chief Magistrate that the then Chief Justice, Mr. Sherman, had sought to influence the Chief Magistrate's decision in a criminal trial which involved the then leader of the opposition, a Mr. Pandey. The case itself, before my lords and my lady, concerns the impact of the exercise of the disciplinary function over judicial officers in Trinidad and Tobago, impacting, of course, on the Chief Magistrate in particular, but on the maintenance of public confidence in the administration of justice and the judicial system of Trinidad and Tobago in general. And it focuses on the Commission's role in the course of events which culminated in the preferment of 6 disciplinary charges by the Commission against the Chief Magistrate, arising out of, and I put it in the broadest terms without prejudice to any submission subsequently developed, of the Chief Magistrate's indication of an unwillingness to testify in criminal proceedings brought against the Chief Justice and the consequent abandonment of those proceedings. But as a result, as the board may know, of the Commission's recent forensic decision, the board is concerned now only with the preferment of 2 out of the 6 charges, the preferment being upheld by the Court of Appeal, which is, of course, the substance of the appeal before the board. It may be useful just to start by reminding the board of the charges themselves, which are now the subject matter of this appeal.
I suspect you don't need to. I suspect they're fresh in our memories, having very recently read the papers.
I'm very much obliged. As you are aware, then, if I can just remind you of the salient features, the 2 charges in particulars are in identical form, although they are entitled or differently located, one being conduct such as to bring the administration of justice into disrepute, and the other being such conduct such as to bring the judicial and legal service into disrepute. But the essence is the same, that the Chief Magistrate, having previously given sworn statements in certain criminal proceedings, informed, and I quote, the lead prosecutor, Mr. Gilbert Peterson, that you, that was he, were not prepared to testify further therein, which conduct resulted in the prosecution being unable to continue the said proceedings, their discontinuance, and the discharge of the said former Chief Justice from the proceedings by the presiding magistrate. Now, we respectfully make four contentions. The first is that it was ultra vires for the Commission to prefer those two charges in their final form in circumstances where it had not been the subject of the initial allegation, had not been referred as such to the investigating officer for investigation, not sent to the Chief Magistrate for him to comment upon them. So that's the first point, which I'll call for convenience the ultra vires point. The second point is that the Commission ought, as a matter of fairness, to have allowed the Chief Justice, the Chief Magistrate, to make representations as to whether the charges should be brought or pursued at all, though that obligation, we say, arising out of a variety of interlocking factors. Firstly, the Commission's own failure, critically commented on by the courts below, to keep confidential its investigative and deliberative procedures. Secondly, its silence in the face of the adverse media publicity and excoriation of the Chief Magistrate, which resulted from that disclosure. Thirdly, the delay in preferring charges between the 9th of March, when the Commission were first seized of the matter, and the 2nd of August of 2007, while the damage to the Chief Magistrate's reputation arising out of media coverage intensified. And fourthly, which is of course related to the first point, the sending of an original letter dated the 9th of March, which led the Chief Magistrate to believe that the only allegation which he would be called upon to answer was actually a refusal to testify on the 5th of March of 2007, when the criminal proceedings were brought before another magistrate in Trinidad and Tobago. We call that, for convenience, if we may, the fairness point.
Well, Mr. Belfour, yeah, all those subheads 1, 2, 3 and 4,
yes,
don't seem to me to be of the essence of the point that he wasn't allowed to make representations. The essence of the point is that he was faced with a charge on which he had been given no chance to comment.
Yes.
And you would be making the same point without any of these sub-features.
Well, the fourth point is, in fact, a re-rehearsal of the first ultra vires point. My Lord is quite right, and in many ways, logically, one might have put that first. But the other factors that we mentioned in our respective division are germane, because a previous decision of this board indicates that in certain circumstances, unusual as they may be, it is right, in fairness, that someone should have the opportunity of seeking to persuade a tribunal or commission that charges should not be brought at all, rather than simply awaiting the hearing before the tribunal and seeking to make out the case before them. And we should be respectfully submitting that certain of the criteria identified in Rees and Crane can be read across here. In any event, as it were, without suggesting that the point my Lord in the chair makes is not the strongest of the points in relation to the fairness issue, we don't abandon the moment until compelled otherwise.
What was the first of the 4 points?
The first of the 4 points was that the Commission themselves had failed to keep confidential their processes of investigation and deliberation.
Yeah. So are you saying that all these things made it all the more important that you should have a chance to scotch the thing,
yes,
before
absolutely.
any further prejudice developed?
My Lord is quite right. In a sense, I should have made the fourth of those 4 headings first, and the others to be supplementary. Well, the third point, again a discrete point, is that the 2 charges which presently the Chief Magistrate faces were unsustainable in fact and in law for three reasons, again overlapping. The first is the Chief Magistrate actually had no opportunity to testify on the 5th of March at all, since he was asked no questions after he was called into the witness box, and accordingly he didn't refuse to testify in the face of the court. That was the original allegation.
But that's not the allegation you're now
Not
dealing
the
with.
allegation he's now making,
No.
but we say that the moment they retreated from that, which, had it been capable of being made out, might have formed the basis for a proper charge. In a sense, they abandoned the very essence of the complaint. And we add to that, as we shall submit briefly, that the Chief Magistrate was actually, in right of being a judicial officer, asked to give evidence in relation to functions that we say were intimately related to his judicial post. He was not compellable at all. And finally, we also say it wasn't he, it was the Chief Magistrate, the prosecutor, or the presiding magistrate who were responsible for the fact that the proceedings did not continue. And then fourthly, which is and we called that, just for convenience, the unsustainability point. And fourthly, is a supplementary point, that the matters we have already alluded to, certainly under the fairness point, coupled with the fact that before the Mustill Tribunal, as it's colloquially known, which was established to inquire into the allegations made against the Chief Justice under Section 137 of the Constitution, the result of that was that the Chief Magistrate was exposed to hostile cross-examination in relation to the very issues that the tribunal would, if the matter continues, be seized of. And in those circumstances, we submit the Commission ought at the very least to have considered whether fairness required the withdrawal of those two charges, because in a sense this compulsory disclosure of a defence which was then, as it were, publicly disparaged, and we've called that the oppression point. Now, I've given them these titles for a particular reason, to identify that my learned friend Mr. Knox has courteously indicated, and indeed his printed case suggests, that he takes objection to us raising the ultra vires point, part of the unsustainability point and the oppression point, on the grounds that none of these points were raised below. We dispute both the premise of that challenge and indeed in any event its conclusion. But in order that both the nature of the points we do seek to advance and whether they are indeed available to the appellant before the board, it will be necessary to describe to my lords and my lady the history of how the two surviving charges were generated and how they were disposed of in the courts of Trinidad and Tobago. My learned friend, very kindly, no doubt he'll confirm this, says he takes no objection to that course. In other words, he doesn't wish, as it were, to have an interim argument about
the usual Gabini essay approach.
Exactly.
Very well.
That's right. I'm very much obliged. Now, the factual background is reasonably amply set out, as it should be, in the agreed statements of facts and issues. But I will, if I may, take your lords and my lady briefly through that and pause from time to time to look at the very few documents that are actually critical when one comes to consider the 4 points that we seek to advance. So if one, as it were, could use that as a point of departure, and then, as I say, from time to time, investigate or look at the primary documents which have now been added in supplementary bundles to the record. One starts, if we may, at paragraph 6, which says, which refers to the initial complaint by the Chief Magistrate of the attempt by the Chief Justice to influence him in the exercise of his judicial functions. At the next paragraph 7, we refer to the fact that Chief Justice, as it were, being perhaps putting it vulgarly, as it were, tit for tat, make the written complaint to the Commissioner of Police about the Chief Magistrate's complaint against the Chief Justice, and then, for good measure, makes allegations about a land transaction which the Chief Magistrate was said to be involved. The Chief Magistrate then gives a series of detailed statements on both those issues which we refer to in paragraph 8. And then pausing here on the 14th of February, this is at the paragraph 11 of the statement of agreed facts, it is accepted that the Chief Magistrate did swear written statements for the purpose of the criminal proceedings contemplated against the Chief Justice to the same effect as his general complaint against the Chief Justice, but already indicated that he was reluctant, in fact, to give evidence in criminal proceedings to that effect. One then comes to the circumstances of the 5th of March, because it's in relation to the events of the 5th of March that the two surviving charges relate. And for this purpose, I'd ask you if you'd be good enough to look at something that is somewhat strangely headed embargoed documents, but are not in fact documents that either side believes that the committee is not entitled to read, and to look at two of the statements that were made to the investigating officer, Mr. Justice Ventura, about what was envisaged and what in fact happened in relation to the events of the 5th of March. First, I'd like to look, if you would. Unfortunately, this is not paged in any very intelligible way. These are all documents that are annexed to the investigating officer's report, which is at tab 10 of that bundle. And I wanted to refer you briefly to two of these statements, one made by the Deputy Director of Prosecutions, Carla Brown-Antoine, which is not padded, as it were, I should say, approximately 10 pages into that exhibit.
This is the bundle entitled Documents Under Embargo.
That's the one, yes.
Mine's tabbed.
It should be tab 10.
Yes, tab
10 pages in, and what do we find?
You should find, dated the 28th of March of 2007, from the address of the Office of the Director of Public Prosecution, a statement of Miss Carla Brown-Antoine. It's opposite a letter with the same heading from the Lady Deputy Director to Mr. Justice Ventura. It's Appendix C. I mean, that only helps to the extent that it isn't again
Page 3 of Appendix C.
It's page 3 of Appendix C, yes. Do my lords and my lady have that now?
Yes.
Yes. Now, again, I take a very, very summary approach to this. There are just certain paragraphs. One doesn't need the whole story. At paragraph 6 on the first page, one sees that prior to the retainer of Mr. Peterson of Senior Counsel to lead for the prosecution, I had taken a decision to proceed by way of written statements and communicated that decision to the attorneys representing the Chief Justice. If we then go forward without the intervening paragraphs, all of which now, in a sense, have disappeared, given the fact that the supplementary charges are not being pursued, if one goes to paragraph 22, one sees that the proceedings, the preliminary inquiry, PI as it's called sometimes, on the 26th of February had begun. The prosecution tendered into evidence 22 statements of its witnesses, including the 4 statements I've already referred to, sworn by the Chief Justice. There was no objection by the defence to any of the statements or to any material contained in them. And then, this is significant, at the end of this process, this is paragraph 23, defence attorney for the Chief Justice indicated that the only witness they required for cross-examination was Mr. McNicholls. She then goes into why it wasn't possible on that date, since he was performing judicial functions elsewhere, for him to give evidence. She then, at paragraph 27, across the page, she says that on the morning of February the 28th, when a matter was set for hearing, I was informed by the DPP that the Chief Magistrate, I'm putting in the titles rather than the names, had called to indicate he was going to attend the court to testify in the matter, but he was unavailable on the 28th of February, but would be available to attend court on the 5th of March, and had asked for the statements that he had already provided. Then one sees that he'd given the indication again, and again this has been abandoned as a ground for the charges, that he was reluctant to give such evidence. And then one sees at paragraph 33, when the matter was called on the 5th of March, I was present and I heard Mr. Peterson indicate to the court that Mr. McNicholls was outside. He then tendered into evidence two of the prosecution's outstanding statements which had been sworn and filed. Mr. Peterson then said to the court he was calling Mr. McNicholls. After his name was called outside, Mr. McNicholls entered into the courtroom, went to the witness box where he was about to be sworn, and then she goes on at this point, and I'm going to take you actually to the transcript very briefly, so this is a summary. It was called in, no questions were asked, etc. The magistrate discharged the accused, and then her own comment at 38, the intervening paragraphs, it's better to look at the actual transcript, which is best evidence. I believe it would have been preferable for the witness to indicate for himself from the witness box he did not want to give evidence. The record would then have reflected the reason the prosecutor adopted the course he did. Nevertheless, I did not think there was anything wrong with the procedure adopted. I was of the opinion that the court could accept the word of an officer of the court and minister of justice, as say the prosecutor as the position of the witness, who then refers to a letter which he belatedly responded.
But the paragraphs you've omitted actually won't appear from the transcript.
No, they won't.
What they recall is a conversation at the prosecutor's table.
Yes.
When he said, apparently, in the court, but privately, not necessary to do anything more.
Which paragraph is my lord looking at?
36, 37, you said
36 and 37.
not necessary to read
Oh, yes,
because
I'm
it'll
so
appear from the
sorry.
transcript, but
Yeah. You're quite right.
it won't appear from the transcript,
No,
and it might be quite important.
Well, if my lord thinks it's important, perhaps one should read it then. I mean, first, 34, Mr. Peterson then said to the court he was calling Mr. McNicholls. After his name was called outside, Mr. McNicholls, the chief magistrate, entered the court and went to the witness box where he was about to be sworn. At this point, Mr. Peterson rose, told the court, having regard to the position, etc., we're not proceeding, asked the accused to be discharged. Mr. McNicholls came out of the witness box. I then indicated, my lord's quite right, I should have read this to Mr. Peterson, the witness should go into the witness box and state his position. Mr. Peterson then spoke to Mr. McNicholls at the prosecutor's table. I did not hear that conversation. Mr. Peterson then indicated that Mr. McNicholls said this was not necessary. He then left the courtroom and the magistrate discharged the accused. So what one has there, before we actually come to the transcript of what transpired, is, firstly, criminal statements had been provided for the purpose of criminal proceedings, although on several occasions the Chief Magistrate had indicated that he did not wish actually to give viva voce evidence in the criminal proceedings. Secondly, that he was summoned to be present only for the purposes of cross-examination. Thirdly, that in fact...
But that would be standard, wouldn't it? I mean,
yes.
Presumably in all these cases, you only have to produce a witness if the defence wants it.
Absolutely. That is.
And then he's simply cross-examined. He doesn't give any further evidence in chief.
No. Of course, he wasn't even given the opportunity to refuse to be cross-examined.
Do we have a statement from Mr. Peterson saying what was said
Yes.
at the prosecutor's table?
Yeah, we've got a statement from Mr. Peterson. Now, that's a little bit further on. That's at tab 11, a continuation of Appendix C. It's not, in fact, paginated, but again, it would be good. It comes after, a little while, a few pages after the transcript of what took place on that day, which I'm going to need to return to. That's really page 3 of Mr. Peterson's statement. Page 2 makes clear that the purpose, as my Lord Clerk suggests, of him being called at all was to be made available for cross-examination by Mrs. Elder, who was senior counsel appearing for the then Chief Justice, and an undertaking had been given that he would be produced for that effect. And then at page 3, Mr. Peterson deals with the events of the 5th of March. And the first 2 lines, the Chief Magistrate called me at my chambers, told me he was returning my call from the previous evening. He'd not returned my call early, it's been too late, and he retrieved my message and voicemail. Chief Magistrate, he again wanted to make his position clear. He was not prepared to testify on the matter. I said, okay. I also told him, he'd said that to me before, and I'd called him to ensure he would be attending court later that day. I considered it important to know the Chief Magistrate's position, as I'd given this undertaking to the court on the 28th of February. He would be in court. The Chief Magistrate said he would come to court. Then on the 5th of March, between 12:10 and 12:30, I telephoned the Chief Magistrate. I asked the Chief Magistrate to give a statement to the Inspector, setting out that he refused to testify the reasons for the refusal. Chief Magistrate told me he didn't consider it necessary to give a statement. He'd already indicated his position to me as the senior in the matter. He'd also done so in a letter to the Director of Public Prosecutions. I understood him to be referring to the letter, which is in fact opposite to the page at the letter of the 13th of February. And then before the witness was called, at 1 p.m. on the 5th of March, I had a discussion with Mrs. Braun-Antoine about the future proceedings against Mr. Sherman, Chief Justice. We agreed that given the position taken by the Chief Magistrate, it would be improper to continue the prosecution of Mr. Sherman, as the charge would not stand without the Chief Magistrate's evidence. When the matter was called at 1 p.m. or thereabouts, I indicated to the court the Chief Magistrate was present. He was called, he entered the courtroom. Before he could be sworn, I indicated to the magistrate that based on the position which Mr. McNicholls had indicated to me, the prosecution against Mr. Sherman could go, in fact, no further. It should be clear that the decision to proceed in this way was mine. The magistrate then discharged the Chief Justice. It's not actually wholly consonant.
Indeed, there's no suggestion of a discussion at the prosecutor's table in paragraph.
Well, there's not only is there no discussion to that, but it's also not consonant in the way in which Mr. Peterson put the matter very obliquely as to the fact that the prosecution were not going to continue. They just, well, you'll see if you go back to the transcript, which is a few pages earlier on, what actually transpired on that day. And this is the official record.
This is still flag 11, isn't it?
This is still flag 11, just going a few pages back. Do my lord and my lady have that?
No, I haven't.
It's near the beginning.
Just towards the beginning.
Yes, I have now.
Yes. At the first page, one sees proceedings commenced at 1:03 p.m., a certain amount of courteous interchanges. Mr. Peterson informs us the third of the way down that Mr. McNicholls, the Chief Magistrate, is in fact outside and advised the statements of the complainant.
This is all very odd, really, if they'd already decided not to go on the basis of his previous indications.
Yeah, well, it is somewhat peculiar. And exactly, I mean, in a sense, one might have thought from the statements, and indeed from the charges, that nothing had happened that day other than the effort to persuade the Chief Magistrate to give evidence and a refusal to do so, etc. But you see, as my Lord Clerk rightly points out, there are a series of procedural steps taken which are inconsistent with, by then, a fixed decision based on what the Chief Magistrate had said to Mr. Peterson not to proceed at all. In any event, if one goes to the second page...
Well, one doesn't know. I mean, they may have thought there was some ritual they had to go through, in which case they didn't complete it.
Well, one can't do more than look at the record and what
it's
Mr.
a matter
Peterson
for evidence,
says.
isn't it?
It's a matter, yeah. I mean, all that's actually important, you may think, and we would respectfully submit, is what happened when the Chief Magistrate was in fact called into the witness box, and that's at the second page at line 38 towards the foot of the page. And now this I will read. Yes, ma'am, Mr. Sherman McNicholls is outside the court. Call your witness, Mr. Prosecutor, and then Inspector Romney calls Sherman McNicholls. Call the name Sherman McNicholls. Try Chief Magistrate Sherman McNicholls. That might do it. Mr. McNicholls, would you step into the witness stand, please, a minute? And then, before anything else happens at all...
We don't, I mean, a minute might be anything. It might be, just wait a minute.
Yes.
Maybe something happened then.
No, I suspected just that, wait a minute. I mean, that's what I interpreted as meaning. I don't think this is, as it were, a note made by the transcriber.
No, I mean, it may be that something happened which was not recorded at that point.
Yeah, that's possible. That is possible. I mean, that would be consistent with there being some kind of discussion between the Chief Magistrate and the prosecutor. It's not, in fact, what Mr. Peterson's statement itself.
He may have been taking some instructions, and he may have been hoping that there'd been some change of mind.
But if that's right, of course, Carla Brown Antoine's got it slightly the wrong way round, since she suggests that the little break was after Peterson had announced. But it may be, she said, at that point.
Yes. In any event, I mean, the fact of the matter is, he's called into this witness stand, a minute is asked for something, we're not certain what happens, but anyhow, it's not something that clearly involves Mr. McNicholls, who's really been called in the witness box. And then Mr. Peterson says, ma'am, having regard to a position indicated to us by this witness, we're adopting a particular course in this matter. It's very discreet, even Delphic. We're not proceeding any further with this prosecution. We're asking that the accused be discharged. Chief Justice Sharma, Chief Magistrate, would you step out to the witness stand then, before the witness leaves? Mr. Peterson, yes, ma'am, I'm asking the Chief Justice be discharged. Worship, you're proceeding no further. Question, Chief Justice, would you stand? The prosecution is not offering any evidence in this matter. You're discharged. You're free to go, sir. Mr. Sharma, thank you. And Her Worship, go ahead. So one can see, if I may put it that way, why it is that eventually it was decided not to charge the Chief Magistrate with a refusal to testify in the criminal proceedings, because when he was called into the witness box, he wasn't given any, as it were, opportunity to repent or pressed or asked whether he wanted to take advice or argument that it was in the public interest he should be. Nothing of that kind. The matter was aborted before that matter could be resolved one way or another.
Well, what we do not know is whether at the moment critique, just as he was about to be called into the witness box, he confirmed to Mr. Peterson, no, I'm standing firm, I am not going to give evidence. And that may be a critical issue if this matter goes further. It's simply not something that Mr. Peterson has dealt with.
No, but I hope realistically have to accept that on a number of occasions, including at some time on the morning of the 5th of March, the Chief Magistrate had indicated that he was not prepared to give evidence in the criminal proceedings. But what I say is whether that was earlier in the morning or whether it was, and it's not been suggested, in fact, in the original charge, it's been abandoned, that it was, it were, reconfirmed on a number of occasions, including just before he went into the witness box. Our point is simply that until he went into the witness box and was sworn and was then asked questions, presumably, in fact, by defence counsel, and then refused to give evidence. Until that time, in our respectful submission, it could not be said that he had refused to give evidence, and indeed, in our respectful submission, not being given the opportunity to repent his previous indication, he was not, could not be said to be guilty of any misconduct simply by reason of those previous.
I mean, that's a very strange and rather formalistic proposition, isn't it? If a chief magistrate feels that there's been an attempt to corrupt him, and he gives a lot of statements as a result of which a criminal prosecution is mounted. And then at the very last minute, he says, well, actually, I'm not going to pursue this, and he doesn't give any reason which is related to the correctness of what he's previously said. One would have thought that he was acting in a way which was extremely debatable from the point of view of the maintenance of justice and an appearance of justice. And why does it matter that it's actually, whether it's actually done in the witness box or done shortly before? The fact is, as one would expect a judicial officer who's made such serious complaints to pursue them.
Well, first of all, let me make it clear, it was not that the Chief Magistrate, as it were, was withdrawing, denying the accuracy of the complaints he'd originally made. His position was, these matters are going to be investigated, as he understood it, in the context of a Section 137 procedure with which, for example, my Lord Sir Jonathan Parker is intimately familiar, and in fact members of the board, as well as the eventual outcome of such domestic proceedings. And indeed, in the event, he did give that evidence to the Muster Tribunal. So it wasn't a case of saying, I no longer believe in what I'm saying. What he said...
All right, but this doesn't go to the question when he withdrew his willingness. I mean, you seem to suggest that it's absolutely critical whether or not he withdrew it in the witness box. But, I mean, he may have perfectly good reason, though I rather question the reason you put forward. Yeah. But that's a matter for argument at the later proceedings. But the fact is that it's really, I mean, the reason I question it, of course, is one can say it's not for him. But it doesn't go to the question, the critical question, which I thought you were focusing on, that it was absolutely vital that he didn't withdraw his willingness in the witness box.
Yes. Well, he's also said on two occasions, one in the statement he gave to the investigating officer and another in evidence to the Muster Tribunal, both of which are matters of record before the board, that had he been informed by the presiding magistrate at the trial that it was his civic or judicial duty to give evidence, he would in fact have done so. That's why I say that the fact that he professes considerable reluctance hitherto, for reasons that he sought to explain, these matters were not actually put to the proof by seeing whether, once you're there being asked to give evidence, you actually do decline to do so.
This all goes to the substance of the complaint. I mean, one might argue that it's hardly very good practice, or that someone should say one thing but then try and say at a later stage, well, if it had been taken further, what I said previously wouldn't have stood. But that, it may be...
There is authority. I mean, your lordship's, my lady's hand, of course, how I develop my suspicion, but there is authority for the proposition. I mean, a rank refusal to give evidence when invited to do so in judicial proceedings constitutes an obvious contempt of court. It has been said in the Court of Appeal in this country that if a witness takes that stand, the sensible course is to give the witness the opportunity to reconsider his position.
And that may be so, Mr. Belf, but here we've got the Chief Magistrate, and you're suggesting that had he been reminded by the magistrate hearing the case of his civic duty, as you describe it, then he might have had second thoughts. I mean, is there any credible reason to think that any such reminder would have had any effect at all?
Well, I put it back, is there any credible reason for disbelieving the Chief Magistrate when he says this? I mean, it is one thing. There are many circumstances in life in which one may say, I'm going to take a particular position, but when, to use the vernacular, push comes to shove, one doesn't take that position. And one of the factors might be, well, the kind of factors I say that alluded to in the Montgomery case, that one is reminded one's got a duty to do so. I mean, one has to recognise that this is not someone, first of all, I hear vehemently to the point, that he never backtracked on the accuracy of what he was saying. He didn't completely abstain from involvement in the prosecution process. He gave statements that were intended, as he knew, to be used for the purpose of the prosecution. He'd indicated in the interim that he was very reluctant, indeed was not prepared to give evidence in relation to them, but he did come to court. He didn't simply decline to come to court on the day in question. And as one said, against that background, why should one not say that if the critical moment came and he was reminded of his duty, that he might not have complied, that he just didn't, let me put it like this, he didn't want to unless he had to.
But I don't see that, even if you're right about that, it has any bearing on whether the charge of misconduct is sustainable. I mean, the fact is that the prosecution acted as it did because of his statements, and the fact is that his statements were not in accordance with what one would have thought was a chief magistrate's civic duty to uphold the system of justice and administration of justice if he thought that someone was trying to corrupt him, and he made a clear statement that he wouldn't give evidence at some point, you accept. Why isn't that by itself, even if privately he was thinking, well, I might change my mind, why isn't it misconduct?
Well, can I come to that, as it were, my heading 3? Because at the moment I'm simply taking... Your Lordship has clearly alerted to me the problems I may face
I
on that
doubt
element.
he needed any such warning, Mr. Beloff.
Well,
With this whole discussion is it shows that there are some matters for trial, as far as I can see. But I do see that's your third point.
Yes. But the 2 points overlap in a way, because your theme is that there's all the difference in the world between refusing to answer when the first question is put to you in cross-examination and giving a prior intimation that that is what you're going to do.
Yes.
And that as he'd only been forewarned of the latter, he didn't have due warning, or he wasn't given the gist of the case against him at all. That's what you'll say.
But also, I suppose you can be, as far as I can see, your best point is, if you like, this, that the point he was making was that these criminal proceedings shouldn't go on until after there was Section 137. He never said he was going to withdraw. No. And he subsequently said if that point was a bad one and it were ruled that the proceedings should go on, there's no basis for the conclusion that he wouldn't have given evidence, because he never withdrew the position. Now, that's one possible view. And the other one is the one put by my lord.
yes.
And your difficulty is that these are all matters for the disciplinary tribunal.
Well, let me put it this way. At least I'm glad there is another possible view. I may try to convert it into a probable or even a certain in the course of submission. But at the moment, indeed, that, of course, is effectively how I do put it. But the point that my lord in the chair, the President, makes to me about the actual charge which he believed he was going to face being actually different from the charge that he now faced is actually freestanding. As long as one accepts that they are different, ultra vires point, as we shall submit, ought to succeed by itself without prejudice to the other points. But I'm coming, as it were, I'm simply taking your Lordship and my lady, and I hope helpfully through the record. Once I've done that, the points are relatively short.
Yes,
I think
well,
my learned friend and I both agree on that proposition.
Is there any evidence of fact from the Chief Magistrate which bears upon the issues we've just been looking at?
Yes,
for example, whether there was any discussion at the table and all that.
Well, we've got the statement. We've got the statement that he gave in relation to the investigating officer, and we've also got the transcript of those passages in the hearing before the Mustel inquiry in which he was cross-examined about these matters.
Right.
Can we then, if it's convenient, just remind you, since, as it were, you have the page virtually open at that point, the letter of the 13th of February, which is just behind Mr. Peterson's statement that we looked at a moment ago, and was then responded after the 5th of March hearing by Ms. Brown-Antoine. This is the letter of the 13th of February of 2007. It's the last, it should be the last document in the embargo bundle.
Yes.
and I'm just taking them, I'm sure this has been read by the board. I mean, he said, the first paragraph, I've been told they're going to be section 137 proceedings. He then says, I know I'm chief magistrate, I'm the main witness, but he wants to take steps to stay the instant criminal proceedings because he says the integrity of the judiciary has been restored by the finding of the Commission. The Chief Justice's complaint against me was baseless and the subsequent decision of the Privy Council. My primary concern has been the preservation of the integrity of the judiciary. Any criminal proceedings coming at this juncture, when those section 137 proceedings are afoot, give the appearance of oppression. My statement was originally made to the Prime Minister in support of 137 proceedings. I supported criminal sanctions only when it became clear the Chief Justice blocked 137 proceedings. There was a aborted judicial review there. He since lifted his protest to such proceedings. And my junior officer being put in a dilemma to adjudicate on a matter concerning my testimony at a time when the judiciary is only now beginning to heal. It remains my view the good of the country requires this matter be conclusively and quickly determined. This is less likely criminal proceedings than in section 137 proceedings. So here, as my Lord Clerk said, I mean, he hasn't said what I said was untrue, and I'm now trying to retreat from that position. He's saying, my view is that there should not be concurrently criminal proceedings and 137 proceedings, and it would be more effective and useful in the public interest if the 137 proceedings were to take place in advance of, and indeed possibly forestalling the possibility of criminal proceedings, and that's what I would wish to happen. Nothing here suggests I wouldn't give evidence in those proceedings, as indeed he did. He didn't receive a reply to that letter until after the events of the 5th of March. And one then needs to see the reply that he received. This is referred to in the statement of agreed facts at paragraph 14. The actual document itself is in the supplementary record, volume 2 at 1763.
Did you say 1763?
1763, my lady, yes. It's exhibits contained in the supplementary record, volume 2. And this mercifully has got pagination. I don't know whether we this comes, as I say, on the 5th of March, and it starts off by referring to the fact that you adhere to the position that you adopted. And she says, didn't reply earlier because you indicated you were going to attend to give evidence, and therefore the issues raised in your letter did not arise for immediate response. She then says, she's come to the conclusion there's no power to stay the criminal proceedings, pending the outcome of section 137 proceedings. One may debate the legal accuracy of that, but certainly not the good faith of what they're said. And then she said, I must indicate the position you adopted in your letter to be untenable for the following reasons. One, having regard to your professional opinion, I'm of the opinion the integrity of the judiciary would have been best served by your fulfilling your obligation to support the serious allegation you made with your sworn testimony. Criminal proceedings were commenced after a thorough and well-publicised criminal investigation, well prior to any initiation of section 137 proceedings. Although your initial statement was given to the Prime Minister in support of section 137 proceedings, it was the Prime Minister who referred your statement to the attorney referred to the statement to the Commissioner of Police, investigation which preceded these charges. 4, you quite properly cooperated in the criminal investigation by providing detailed statements to the investigators about the alleged conduct of the Chief Justice and also about your personal financial transactions said to be connected therewith. And I remind you, there were 4 separate statements made, all of which were bundled. And then although the magistrate presiding the preliminary inquiry is your subordinate hierarchy of judiciary, when she presides judicial officer, she's independent. No question of hierarchy arises. She ends up, I was constrained to act in this matter as I would in any other prosecution.
Does she say when she wrote that and when she sent it?
If one goes back then to the embargo statement, that's where she deals with this matter. If we go back to that in the just behind Appendix C, Yes, that's right. Yes, that's the one.
Paragraph 52.
Sorry? Sorry. Paragraph 50. At 21, she deals with the, on the 23rd of February, she said she apologises for not responding to his letter. I indicated the position of the prosecution was the preliminary inquiry would continue. We anticipated continued cooperation. I said in taking decisions in the matter, prosecution was guided by three things: public confidence in the administration of justice, independence of the office of the GPP and his credibility as a witness. He indicated he understood our position. And then he deals she deals, as you've already seen, with what transpired on the 5th of March. And then at 39, she says, I amended the draft response to Mr. McNicholls' letter, and the response was sent to Mr. McNicholls the next day. So that one derives from that although she had already, as it were, had a version of a response available, she amended it. Presumably it's a reference to, maybe to the second sentence of the letter of the 5th of March. In any event, she didn't send it until the next day, so that the decision to send, as it were, was subsequent to the events in court of the 5th of March. That's the best answer I can give on the evidence to my class edition. And perhaps paragraph 27, it's helpful.
That's why they don't send it.
Yes. Yes, paragraph 27, when the matter was, I've read this before, I've read that particular paragraph before, and it's the last sentence that's germane, as my learned friend Mr. Knox helpfully points out, sotto voce. He indicated that since, this is Mr. Peterson, that since Mr. McNicholls was going to attend court to give evidence, we should not send the draft response to him as yet.
Do we have the draft response?
Yes. Paragraph 26.
Yes, it's marked E. Where is E?
I think it's a sort of 28.
Oh yes, it's going. Yes, it is. It's dated the 28th of February. It's unsigned.
Where is it in the bundle?
It's in the bundle in tab 10 about appendix. It's another exhibit to the investigating officer's report. It's about 3 pages after Miss Brown-Antoine's statement I just reread, or passages of which I just reread to the board. What is in fact...
Just find that.
Yes.
Yes, right.
Yes, I mean, I haven't, as it were, gone through a textual analysis of the difference between this and the final letter. One notes there's a reference in the second paragraph to considering all the principles of law that may be applicable to your request and position you've adopted. Then what follows thereafter is, as it were, common to the letter eventually sent, other than sub-paragraph 6, where she says in the draft, no one can deny this matter should be conclusively and quickly determined. However, once a prosecution has been brought against anyone, it's incumbent upon the prosecution to fairly and fearlessly conduct the prosecution, while the convenience of the prosecution, the fact to be taken with same dates of the hearing, ultimately the presiding officer determines.
Seems to have abandoned threat in bold at the end of
yeah, well, that's the next, yes, exactly.
Although, does she ever give any reasons?
No. There's a
These are all matters because she can no doubt be asked about.
yeah,
Well, she's done it because after that they've already tossed their hand in.
were the matter to go ahead, my lord, she asked about them, but
John, I mean, were you right to jump ahead again on your point that he's not Helen? Then that actually, although it's not mentioned,
This letter was
would have been a reason.
might be a reason why they didn't actually try and call him.
That's possible.
But it doesn't necessarily answer the question of misconduct, is it? Because
No.
having a non-terrible doesn't mean that it may not be internal misconduct, refused to go to the witness.
That is true. On the other hand, there's no indication that the Commissioner so far considered that particular matter. It might have been a matter again if he'd had the opportunity of making representation. He might have said, well, perhaps in those circumstances not. Can I also say one which is quite interesting here is that Miss Brown-Antoine, one of the reasons she gives for not sending the letter earlier is that at the end of paragraph 27, he indicated, Mr. Peterson, since Mr. McNicholls was going to attend court to give evidence, we should not send a draft response to him as yet. And I agree. One does get the impression throughout that although they had recognised, as the Chief Magistrate himself has said, that he wasn't willing to give evidence, they hadn't actually abandoned hope. And indeed, one of the reasons I say for not sending the response is that they anticipated he would attend. Well, let's wait and see. Now, what did, of course, happen was that earlier on the 5th of March, he did reiterate his particular view, and that's what led Mr. Peterson to do what Mr. Peterson considered appropriate, although it's interesting again that Miss Brown-Antoine, for her part of paragraph 38, did think that it would have been preferable to see whether, if actually asked to give evidence, Mr. McNicholls would have refused to do so, although she was prepared to say that she didn't want to quarrel with the way in which Mr. Peterson himself decided to handle the matter. So all this, as it were, does suggest that even until a very late stage, it wasn't regarded as self-evident that merely because he'd expressed a reluctance and given justification for his reluctance to give evidence in the criminal proceedings, that necessarily he would in fact refuse to do so if caught into the witness box and asked the question, which, as the board knows, he never was.
All these are, no doubt, matters and arguments which you could address if the proceedings continue.
Well, obviously, were the board to decide the proceedings had to continue, those arguments would be available. Non sequitur, that they may not be points that could be made in order to prevent the proceedings going ahead at all. The Chief Justice then, the Chief Magistrate then issued a press release in which he sought to explain his position, a position obviously that was in public knowledge because of what transpired in open court on the 5th of March. And you find that in the supplementary record at part second bundle of authorities, the second bundle of additional documents. And again, perhaps it's page 1770. What he says, I mean, the first paragraph is important because of the suggestion somehow that he initiated what I think is called a press war by the respondents. What he said is, as a great deal has been reported and said about the events of last evening, I break the silence normally expected of a senior judicial officer to dispel some of the unfortunate and scandalous assertions which have been given prominence in the electronic and print media. So this was not, with great respect, an aggressive step. It was a defensive step to criticisms that had already been made by the press and the electronic media. What he then says is, I made this statement in relation to the Panday matter to the Prime Minister. He then refers to the hearing before the Privy Council, in which, as my Lady Baroness Hale and my Lord Mance will recollect, the then Chief Justice sought judicial review of the proceedings to prosecute and was unsuccessful before the board. In the course of that, members of the board made certain observations about the undesirability of there being a coexistence of criminal proceedings and judicial review. Now, whether or not the Chief Magistrate was right to interpret that as equally applying to criminal proceedings and a Section 137 inquiry may be a matter for debate.
I thought obviously not.
Well, he obviously... I'm not going to defend the position, but one understands there's no reason to doubt his good faith in that interpretation of an undesirability of parallel proceedings. Then he says at the foot that the statements are being to be of use in both sets of proceedings, in my view, in defiance of the guidelines provided by the Privy Council. Well, no doubt he was wrong about that, but that was the view that he took. And he then goes on to say, I'm willing to give evidence and eager to do so in proceedings which it is now public record have been instituted under Section 137 of the Constitution of Trinidad and Tobago. So it's nothing to do with a reluctance to testify, it's everything to do with a preference for the forum in which he rightly or wrongly believes that he ought.
I mean, he says there, I affirmed last evening.
Yes.
Is there any evidence of the affirmation last evening? Beyond this?
No. And the affirmation, I think, means no. I don't think it has any technical meaning. I just think he
No, I didn't mean that, but this suggests that he told somebody.
A public statement. Yeah. But in any event, I mean, one might say that whether or not he made it last evening or on the very next day really matters not. I mean, there's no reason to disbelieve what he there says, which is entirely consistent with the position he's been taking, certainly since February 13th letter. And he said, I think they should have been given priority, Section 137, improper to allow cross-examination of two separate proceedings, etc., and that was his view. Rightly or wrongly, that was the view that he took. Well, that was not then acceptable. I mean, he sent to the this is a statement of agreed facts, section, paragraph 16. He sent those letters, the letter of the 13th of February, the response he'd received from Miss Brown-Antoine of the 5th of March, and the press release, all of which you have seen, to the Commission. And on the 8th of March, as the next paragraph, the Commission held an emergency meeting in respect of these events. On the 8th of March, they determined, this is at SF18, that there should be an investigation into the allegations, and there should be drafting of allegations of misconduct. The question of suspension be deferred until completed the Piarco Airport inquiry. It's a long-running saga. It would be obviously grossly inconvenient if he had been taken out of play as far as that's concerned. An investigating officer, Mr. Justice Ventura, was then, in fact, appointed. And again, it's important just to look at the document which indicates his appointment on the 9th of March. It's the same bundle we've been looking at. This is at 1774. And really, all that you need to focus on for the moment is the simple fact, which is undisputed, is that what he was being asked to investigate was an allegation of misconduct that he had, and this is at the foot of 1774, refused to allow himself to be cross-examined on the statements he'd made to the police in relation to the criminal proceedings. The rest is, as it were, common form explaining what the functions of the investigating officer are and the regulations which govern that role. The investigating officer is then...
Can you distinguish that from the allegation now being...
Oh, yes.
And what is the distinction?
The distinction is between refusing to allow yourself to be cross-examined on the one hand, which can only take place if you are asked questions in the witness box and decline to do so, and giving a prior indication of your reluctance to give evidence.
Is that right? I mean, if I say to someone before proceedings begin, I refuse to allow myself to be cross-examined.
You used the word reluctance a moment ago. That's a somewhat colourable way of describing what the case made against
I mean, the
your client.
reluctance was to be cross-examined,
Yes,
because he'd already given his evidence to the chief, and so the only thing that was going to happen was his cross-examination.
I'm going to, I anticipate points that I'm going to make. In the first point, one has to ask oneself is why, if the two were exactly the same, did the Commission find it necessary not to make charges in this form, but to make charges in the amended form? I mean, either they were saying, in which case this was redundant, the alteration, or they have accepted that they were different. And what is more, both Mr. Justice Jamadar and the Court of Appeal, to an extent, recognised that they were different. Indeed, one actually said that the Chief Magistrate was misled by the formulation of the prospective charge being addressed to his attention in that way. Now, of course, my lords, my lady may take a different view, but it's not with great respect.
How was he misled? What was he led to do? Is that point you're pursuing?
Well, he was led into answering a question. Why did you refuse to give evidence? Why did you refuse to allow yourself to be cross-examined?
We haven't looked at what he said.
No, we haven't looked at what he said.
The reformulation,
yes,
I understood, was a reaction to the point he took. He took the point.
Yes.
It's not the same.
Well,
And so they said, well, if that's what you say, we'll go for it.
And that's not the same. I mean, for example, one might well say, I mean, I didn't refuse. My position is, had I been told by the magistrate my civic duty and so on, I would have done so. That's the explanation. And my Lord the Chair may be right. Again, one hasn't got a insight into the precise deliberations of the Commission, but one does know they took legal advice, and one may infer that the legal advice that they received was, you can't pursue this because, in fact, the Chief Magistrate did not refuse to be cross-examined.
Mr. Melloff, can I just say I've got this right? The particulars that are now extant are those annexed to the appellant's case, are they?
Yes.
Numbers 1 and 2.
Yes, that's right.
And so the extant charges
Yes.
are that he informed the lead prosecutor that he was not prepared to testify.
That's right.
And the distinction is between that allegation, not being prepared to testify,
Yes.
and refusing to allow himself to be cross-examined.
Yes.
That is the distinction.
Yes, and it's not with great respect a fine distinction, because it's a distinction that refers not only to timing, but also to location. The indication was given prior to being called into the witness box, and a refusal would have been behaviour in the witness box. And indeed, as I say, the Commission appear to have recognised this, and we respectfully submit recognised it rightly.
Could you just give me the reference to his explanation?
Well, we are coming to that.
It's on the next, about 2 pages on.
Yes, it is. I'm just coming. Can I just, I mean, it's perhaps important to note at 1773 that the Chief Magistrate was properly informed of the investigation, but the investigation was said to be allegations of misconduct on your part in terms of the copy of the letter to the investigating officer hereto attached. So that's where his mind was directed, the one that we have already seen at 1774. And then at 1777, the matter, as it were, is reinforced because there's a press release given by the Commission. This is at 1777, and on the 14th of March, it's referred to in Statement of Agreed Facts at 21, and you see that they refer to the fact they've appointed the investigating officer to inquire into allegations of misconduct on behalf of the Chief Magistrate arising out of his refusal to give evidence in criminal proceedings, etc. And then they make certain other observations that I think are peripheral to the matters with which the board is concerned. Then Mr. Justice Ventura, in fact, faithful to the mandate that he had been given, writes to the Chief Magistrate, this is at 1778, Statement of Agreed Facts, paragraph 22, letter dated the 15th of March of 2007, and again quotes verbatim, of course, the matter which he had been invited to investigate. Then we have the explanation that my lords have already said is of importance, and he deals, as it were, with the matters, as it were, proceeding. I mean, I'll be happy to read this to the board if they wish to, but I don't think until one gets to the second and third page that one has anything which isn't actually repetitious of his previous explanation of his attitude as to why he thought that the Section 137 proceedings should have priority. And he then deals with, as it were, his interplay with the prosecuting authorities and the discussions that he had. And then if one comes to 1781, one sees that he says this, halfway down the page. During the morning of the 5th of March 2007, I telephoned Mr. Peterson and informed him I was not willing to testify. He said, okay, and that was the end of my conversation with him. So that actually earlier in the day, as we know, the material parts of the criminal process occurred at 1 p.m. approximately. Then when the matter was called, I heard my name called at the coroner's report. I entered the same, went into the witness box. As I was about to be sworn, Mr. Peterson told the court he was discontinuing the proceedings because I was not willing to testify, or words to that effect, and the magistrate discharged the accused. When you see the transcript...
Yes, although oddly, in the transcript, there is no reason given. No. It simply said, we are adopting... it simply regards to a position indicated to us by...
That's what I said. Discreet and Delphic was the word that I used.
Yes, no doubt with a rather optimistic eye to the media.
Rather optimistic, maybe, a degree of understanding.
I mean, your line is very extraordinarily narrow, isn't it? Because here we have your client saying, I informed him that I was not willing to testify. Now, the only thing that was going to happen before the magistrate was the cross-examining of the cross-examination of the chief magistrate. So, he was in effect informing him that he was not willing to be cross-examined. So, the line you're trying to draw is one of those now you see it, now you don't lines.
Oh, no, I think one, but with great...
But just looking at the chief magistrate's own statement.
Well, our submission is in law, it's a bright line. I mean...
Well, let's focus on the facts to begin with it.
Well, we can focus on the facts, because a little bit later, this, of course, is the material passage, he said... I mean, can I... Well, he says, if I had been told that I had to, I would have. Can I just read the next...
That's a different point as to what would have happened if he'd gone into the witness box, and I quite understand your point. But the case against him is, and it may or may not succeed at a trial, is that he wasn't willing to be cross-examined. He wasn't willing to justify his statement in a criminal court.
Well, yes.
Well, that's part of the case, but another part of the case is he acted in such a way that applying an objective test was calculated to upset the due carriage of justice.
Yes. Yes, I mean, I am reminded helpfully by Mr. Benjamin that the formulation of the abandoned charge actually said that the refusal took place at the 4th A Court, Spain Magistrates Court. So it's quite clear...
Sorry, where do you...
That is the charge that we've got. Yes, so what is being... It's quite clear that what's being referred to is not previous statements made over the telephone to prosecuting counsel, even on the morning of the 5th of March. It's actually a refusal at the court itself.
Well, if the magistrate's account is right, it's possible that he did, if he said that won't be necessary. The DPP's right. Sorry, the DPP's.
Well,
Charles certainly covers that, doesn't it?
Yes.
Covers any time on
the present charge. Yes. But, I mean, if I may say so, it's rather peculiar that the prosecuting authority or the commission have thought it necessary to amend the charge in the way in which they have, and yet entirely provisionally, as I would put it in an optimistic way. Your lordships are apparently taking the view there was absolutely no need to amend at all. And we do submit that there is. I mean, my Lord Clerk suggests let's look at the facts. The facts are that he was never asked when in the witness box, either by prosecuting counsel or defence counsel, to answer questions and refuse to do so. Those are the facts.
Yeah, your point is still a good one, if by the present charge
Yeah.
the prosecution is intending to embrace either a statement made in court or a statement made before. You would say the statement made before is objectionable on any view.
Yes, I don't mind. For my purposes, it matters not if it was said 3 minutes before, 3 hours before, 3 days before. I say that the Rubicon is crossed here if you go into the witness box and are asked a question.
That's a slightly different point from what I was thinking.
Is it? Well,
There are two Rubicons. You've got one which is going into the witness box. Another one is whether it's actually a refusal at the court.
Yes.
Where is the reference to at the court?
The reference is what Mr. Justice Ventura was asked to investigate.
At the fourth court.
Yes.
1778.
Yes. 1774. I haven't, I confess, been alert as Mr. Benjamin clearly is with his greater knowledge of this to the distinction. I might thank Mr. James.
Seems rather a subtle distinction to me. Maybe whether there was a discussion at the prosecutor's table that may become critical.
Well, I find it very difficult, with great respect, to say that someone has refused to allow himself to be cross-examined, if no one sought to put a question to him in cross-examination.
I follow that, but that's
That's it. I mean, that's my satisfactory. Quite clear.
Of anticipatory repudiation of the law.
No.
I follow that. I'm only on the point about whether the substance of these two allegations are different. You have all your points about it's perfectly reasonable for he's changed his mind, he's given a perfectly good explanation which has got nothing to do with withdrawing the allegations, it's all to do with the section 137 to be preferred point, all that. You've got all those points.
But I do
But
say
the point that they're different seems to me to be quite difficult.
well, only if one isn't prepared to distinguish between an anticipatory statement, to use the phrase.
Now, I take your Rubicon point, the second Rubicon point, but not the earlier one.
Yeah.
Yes, well, the Court of Appeal's with you on this to the extent that they seem to have accepted there was a difference because they say your client had the gist of the case against him when he received the original allegation of misconduct. They say that was the gist of the case that was ultimately made. And for my part, it seems to me that that is the finding you need to attack if you're going to get home on fairness.
These facts are really common ground, aren't they, except on the edges?
Yes. I mean, there is a certain degree of obscurity as to precisely who said what to when on the morning.
But I mean, nobody suggests he went into the witness box or was asked to go to the
I
witness
can
box.
defend.
Nobody suggests he refused to do anything once he was in the witness box.
No. And that's the position that I'm seeking to defend. So all these other matters are to that extent peripheral. I mean, my own opinions may say different, but I say there is all the difference in the world between, etc. Can we just then conclude his statement then that he made, and this was in response to what he thought was an allegation of refusal. I was making up my mind as to whether or not I should testify. I examined the Court of Appeal judgment. I think that must be a reference to the Privy Council in the DPP and Sherman, discovered that in fact their lordships had remarked in a negative sense on the existence of parallel proceedings. I was fortified, therefore, in my conviction the existence of both sets of proceedings against Mr. Sherman by the State would amount to oppressive conduct. As judicial officer, I agonised over whether I should participate in any conduct which I judged to be oppressive. I came to the conclusion after a great deal of prayer reflection I should not participate. In spite of the fact that I'd come to the conclusion not to testify in the Sherman criminal matter, if the DPP's lawyers or the presiding magistrate had indicated to me that my reasons for not testifying were unacceptable, I would have testified. That's what he said. And of course, in a sense, that underlines my point that there is a difference between a position taken before entry into the witness box and a position taken in the witness box. So that's anyhow what he then he there says. Then if one goes forward, one can take up at the rest of this matter reasonably swiftly. On the 27th of March, the Commission met and they discussed whether or not he should be suspended and made inquiries about his list of forthcoming cases. Again, there is a certain sense in which the convenience of process in Trinidad and Tobago was lively in their mind. And then on the 24th of April, they received of Mr. Justice Venture's report, as I'm going to have to return to that later, I merely draw your lordship, my lady's attention to the fact it is in the bundle. They decided at that stage to prefer charges, didn't for some reason inform the Chief Magistrate, received, and again this is very they received some question from Mr. Justice Venture. He'd received a late statement from leading defence counsel. Did he have to revise, go back? They said in the end the report he produced wasn't modified in any material way. On the 18th of May, finally the Mustel Tribunal was appointed, statement of facts, 27 and 28, 21st of May, another meeting, confirmed decision to prefer charges, again didn't actually do so. And then something that did excite considerable criticism and concern in both courts below, that somehow Mr. Justice Venture's report, and indeed the deliberations of the Commission themselves, found their way into the media. And there's a long proof of that if one looks at 1783, 1788, and I will simply say it speaks for itself. They obviously had access, which they should not have had, to the report, and they obviously had access, which they should not have had, to the deliberations of the Commission. From Mr. McNicholls' point of view, it was the consequence of that leak that was particularly damaging, because there was, as one is not surprised, considerable media comment. And one sees right through from 1789 to 1796 the kind of comment that was made. And again, I don't think it's necessary to read this, because the appellate court, and indeed Mr. Justice Jamadar, have rightly described this as being damaging, and indeed the case is being, as it were, debated publicly, and people are, as it were, asked questions about what they thought should happen at 1792. One sees a former member of the Commission believes he should have been suspended, etc., etc. All really matters that really should not have been ventilated.
What happened in the end, so far as suspension was concerned?
He wasn't.
He was never suspended?
No, he was never suspended. And then I don't quite know why the one headed the judge's underpants has come into the bundle, but there it is at 179728. And then, but you see again, on the 18th of June, I think one's got to go forward, the Commission met and they decided to defer their consideration of preferment of disciplinary charges, asked for advice from its legal officer, in particular as to whether or not the Chief Magistrate would be entitled to legal representation, discussed the article that we've just seen, the one that was a complete disclosure of the report and the private matters, decided to issue a press release. That's all in evidence from the deponent on behalf of the Commission. And then, on the 24th of June, the Express, who are obviously dealing with these matters, as newspapers sometimes do, sequentially to whet the public appetite, published the Chief Magistrate's written explanation verbatim. And that's at 1789 and 1799 and following. And again, one has another hostile press comment in those particular pages. Then at the 26th of June, the Commission meet yet again. And again, I mean, just for example, if one looks at 1801, perhaps I should just show you, there's an example. Someone concerned Trinidadian writes right-hand box, McNicholls a bad example. So this is all, as it were, public opinion being ventilated in a manner adverse to the Chief Magistrate, who, if the orthodox process had been pursued, would have had the benefit, as it were, of a private hearing after a private investigation and a private report without, as it were, any elements of purported outside influence. Then the Commission meet yet again, still don't actually decide to let the Chief Magistrate know that they'd earlier decided he was to be charged, asked for senior counsel to represent him. That's at Statement of Agreed Facts Act 32. And then for the first time, Mr. Benjamin and his team in Trinidad enter upon the scene, and they write a letter complaining about the fact that, and again I can summarise this because it's set out at Statement of Agreed Facts at 33, complaining about the fact that there's been this public leakage of confidential documents, asking for some indication as to when and if proceedings were going to be brought, asking for the minutes and reports so that the Chief Magistrate could be fully advised, and they did at the top of 1816 say this: the unprecedented disclosure and liberation of the Commission, the adverse publicity have been and continue to be the extreme prejudice of our clients and undermines any confidence that there may be in the impartiality and confidentiality of the decision-making process embarked upon by the Commission. The Commission refused to make further disclosure to the Chief Magistrate, although obviously they had not reacted adversely to leakage elsewhere. That's at 1818, letter of the 11th of July, not necessarily, it is simply a blanket refusal. And then on the 31st of July, they meet and decide to prefer the 6 charges, the subject of these original proceedings, and that's at Statement of Agreed Fact at 35. And again, summarising now, 2 of the charges related to the prior indication of not going to testify on the 27th of February, 2 relate to similar in relation to the 1st of March. And then 2 charges now relating to the 5th of March, in which there has been the adjustment on which my Lord and my Lady have already focused, which I've mentioned on a number of occasions, namely, no longer that he had actually refused to testify, but rather that on the morning of the 5th of March, he indicated that he was not prepared to testify, and they informed him of the charges that were now to be brought in a letter that one has at 1819 to 1820. They annex the charges in their present form, and I've already commented on the difference between those and that which was investigated, and I invite him to respond, and his response at 1866, I think, right. Anyhow, that he denied the charge. It is, yes, 1866, last page of that bundle. I deny all 6 charges as preferred against me contained in the said letter. And then just one more matter of fact before one comes very briefly to the way in which the matters were handled below. The Mustel Tribunal had already been set up. They conducted a public hearing. The Chief Magistrate did, in fact, give evidence before the Mustel Tribunal. He gave a statement, as one sees. It's in this bundle, and it's a lengthy statement starting at 1828. And again, what it contains, of course, is a statement dealing largely with the discussions that he said he had with the Chief Justice, in which the Chief Justice sought to persuade him to take a particular stance in relation to the Pandey trial. He also deals elaborately at this so-called land transaction. But finally, he does deal with the issue of the witness statements in the criminal proceedings, and that he takes up at 1861. At 65, because this again is really repetitious, he said when he gave his original statement to the Prime Minister, he was assuming it was going to be for the purpose of Section 137 proceedings. When it was brought to his attention the proceeding criminal proceeding would be instituted, he became apprehensive as they weren't of his contemplation. and he, as I say, he misunderstood what the position was when he'd given his statement. Then he deals with all these matters about why he was reluctant. He says because of the long-standing relationship, etc. He refers to his letter. He refers at 68 to what transpired on the date of the 5th of March, and further deals again in a matter that we say is in no sense discrepant with the more abbreviated statement that he'd already provided to Mr. Justice Ventura. At 73, he deals with the circumstances in which he was called into the witness box, and then the abandonment of the proceedings. At 74, he actually said, I was not required, this is the last page of that statement, to identify myself by giving my name, as is the practice with witnesses in the magistrate's court, nor was I sworn. I was completely surprised by what transpired. Now, all I say in relation to that is, I mean, it is actually entirely consistent with what he said throughout, namely, that he wasn't in any sense going to be inhibited in giving evidence on these matters to a Section 137 Tribunal of Inquiry. And when that was set up, he gives an elaborate statement in relation to that.
Is there any issue about that before us?
I don't think there is. No, but the only matter which I just want to draw the attention of the board to is the way in which that particular aspect, the only one with which the board is now concerned, that's to say, why he was reluctant to, refused to, again I'm using this entirely neutrally, give evidence on the 5th of March, how that was dealt with in the proceedings before the Mustel inquiry. That's the last matter of fact that I need to draw to the board's attention at all.
Could I just ask you one
yes,
point of detail? He wrote his letter of the 13th February, and in paragraph 72 on page 1864, after some discussion, he says in the last sentence, I eventually swore to my statements. Let's say swore to them for the purposes of the criminal proceedings. Mm-hmm. In paragraph 11 of the agreed statement of facts, he said he did that on the 14th of February. Is that correct, the 14th of February?
Well, we've got all the statements, which are...
Have we?
It is correct.
We've got the statements, but I'm not sure what the dates in which they're sworn.
Are the dates not provided? Can we just give...
Well, my only point was that the paragraph 72 suggests that it was sometime considerably after the 13th that he swore to the statements, whereas the paragraph 14 suggests it was on the 14th.
He must have, by the 14th, because they send them over on the 14th.
Yes, I think for our part we accept. I mean, in a sense, there was a coincidence of saying, well, yes, all right, I'm going to give you these statements, but I don't want to give evidence. I mean, he was, as it were, at that stage, one might say, on any view, performing his civic duty by providing statements, but perhaps somewhat, depending on one's perspective, qualifying that by a contemporaneous indication he didn't actually want to.
Well, I just wanted to make sure we had the date correct.
I think the date, but I think it's both to my left and to my right,
okay, thank
suggested that the dates are correct.
Thank you.
And then, if you just go then to Supplemental Record, Volume 1, page 1719, cross-examination by Mr. Robertson, Mr. Geoffrey Robertson, I think, the Queen's Counsel, and you see at 1719, the matter is effectively put. Case collapsed because you refused to stand by your statement, and the response that was effectively given, well, that was the prosecution's decision. Yes, at line 7, the prosecutor adopted that course after you made plain that you would not testify. Yes, sir, but clearly if a witness goes into the witness box, the court has an obligation, if he's unwilling or reluctant to testify, to encourage him to do so. That was not done in this case. So, as it were, that's again compatible with an earlier statement that he'd made in response to Mr. Justice Ventura, that had he been told that he had to give evidence, he would in fact have done so. There's nothing discrepant there. And then he does accept that perhaps you should be sworn in your will. You declined to testify. You had a word with Mr. Peterson. It was decided it wasn't necessary. And he says, yes, sir, correct, yes, sir. So that does suggest that he had a brief discussion before with Mr. Peterson. And then he says over the page 1721, are you trying to suggest that if asked by Mr. Peterson, having just told him you weren't prepared to testify, that you would have changed your mind and testified? And then he says, because I was expecting they would have obtained an adjournment, were you a fourth adjournment, not uncommon in preliminary inquiries, and again at 16 to 17, he said, I thought he was going to ask for an adjournment. He's cross-examined on the basis, obviously important that justice is not delayed. And then the Chief Justice in the dock question at 24, you put him there, Mr. McNicholls, don't try to pass the buck, please. You put him there, your lies put him there. I suggest disagreement with that. Weren't prepared to testify for very good reason. You knew well he hadn't committed a criminal offence. Totally disagree with you. Rather worried your own criminal offence would come out in cross-examination. Totally false. And then the chairman, Lord Mustill, intervenes, and he puts the point that do you think the position you took was a tenable position for any witness, let alone a senior judge? And on reflection, the Chief Magistrate agrees that it was not. And he then, Lord Mustill, asks him about domestic violence cases and what happens if there's a reluctant complainant. And one sees at 1723, would it not be your practice to read the Riot Act to and say it's your duty to give evidence, distasteful as it may be? Yes, sir. Normally my practice would be inquire of a witness why he doesn't want to give evidence. Yes, sir. Yes, sir. And if you're right, let's get to this case. I'll be corrected. There's something I forgot. But did you explain to the court why you would not give evidence? No, I said nothing to the court. And then he must have been a big surprise to the magistrate when everything appeared to be in order. There was a witness statement review. Suddenly, a puff of wind, the prosecution collapses. Was that not a surprise to you? Yes, when I turned up that afternoon, so it was out of respect to the court. I did not go prepared to testify that day. I was not expected to be called into the courtroom. Just pausing there, I mean, it's quite interesting that Lord Mustill, obviously with his huge experience, is debating with the Chief Magistrate what happens when you are performing your judicial function, sitting as Chief Magistrate, and you have a reluctant witness. And what he's saying is what you would do is say to the witness, you may be reluctant, but it is your duty, in fact, first of all, to find out why the witness doesn't want to give evidence, and then to explain that it's a duty to give evidence. Now, the Chief Magistrate was never given either of those opportunities. When he said, I said nothing to the court to explain why you would not give evidence, he said nothing to the court because the magistrate didn't ask him. I mean, the sequence of events should have been, in the conventional way, Chief Magistrate administered the oath, then someone asked him a question. At that stage, he says, I'm not prepared to give evidence. And at that stage, the person presiding should and ordinarily would have said, why not? And then there would have been a discussion as to whether the reasons were satisfactory, and on the assumption that I would make that the reasons were not regarded as satisfactory, he would then have been told that you are obliged to give evidence and might indeed have been warned that it would be a contempt of court not to do so. None of that happened. He was never given the chance.
But he says in line 20,
Yeah. Yeah. Yeah.
I was not expecting to be called into the courtroom. So
Yeah.
obviously the agonising process that he was going through must have come to an end, and he must have had a firm decision in his mind.
There's no doubt that, well, I mean, I would be prepared to accept that it's an inference that when he went into the witness box, his then state of mind was, I do not want to give evidence. But what we don't know is what would have happened if he'd been asked why, given an explanation, told it was unsatisfactory, told it was his duty, and indeed told what the sanctions were. None of that happened. And I don't think one can infer from that answer anything which contradicts or is inconsistent with what he's said before and said, as I say, both to Mr. Justice Ventura and indeed in answer to questions to Lord Mustill. and then he had said he wanted the matter to be adjourned. Lord Mustill then leaves it then to cross-examining counsel. And then you see it over at 1725. This is, I think, Mr. Morrison, who's another member of the tribunal. The senior counsel from Jamaica. And he asks certain questions about the state of mind that my Lord Sir Jonathan Parker put to me. And those are answered 1275. There's one, line 5. Because, as I said, I was hoping the state would have gotten an adjournment of the matter, you see, and then with the passage of time I would have been better able to decide what I wanted to do. I was not given that opportunity. And then he was asked by Sir Vincent, another third member of the tribunal, did you ask the state to apply for adjournment? I told the state that, yes, sir. Then cross-examination goes on from Mr. Robertson. And it's in that passage of cross-examination that at 1729, between lines 23 and 24, he says, as I said, sir, if the court had indicated me there and then that I had to testify, I would have. So that what one here has, I mean, just...
There's also an exchange on that page between lines 4 and 11
yes.
about a possible discussion with...
yes.
Exchange with Mr. Peterson at the prosecutor's table.
Yes.
And he seems to accept that there was one.
Yes.
He accepted that earlier, didn't he?
Yes, I am prepared to accept that right up to the moment he went into the witness box, he had indicated that though he sees the prosecution, he was not prepared to testify. But as I say, until he was actually asked, etc., one really can't tell what the result would have been. So what one
Could we just go back to 1722 for a moment?
Yes.
When Lord Mustill intervened, what Lord Mustill put to your client is the case that is now made against him.
Yes.
Yes. And he says, on reflection, it was not a tenable position for any witness, let alone a senior judge. Yes. How can you, in the light of that, suggest to us there's not a case to answer if you fail on your other submissions?
Well, the Chief Magistrate's position vis-à-vis certainly the law may be suspect, for example, in relation to parallel proceedings, and he may not have been alive at that juncture to the fact that he might have had some immunity from the need to give evidence at all. And therefore, the fact that he's made that observation in response to Lord Mustill, in our respect, which is not dispositive of the issue.
And it makes it difficult, though, to say that there's no case to answer. It may not dispose of the case because there are all these other considerations you mentioned. Who is the tribunal going to be if there is a tribunal?
It's constituted by probably the present Chief Justice now. Not the present Chief Justice, they're senior counsel. I mean, there are, one sees the composition of the commission. I don't know who the tribunal is.
He might not be keen on Lord Mustill.
But I'm told it have to be members of the senior, those in the judiciary of Trinidad and Tobago are senior to him in the judicial hierarchy. That seems to be accepted on both sides. There may be a regulation. There are perhaps if we can find the regulation, we'll give it to the board if we may. Then the rest of the statement of agreed facts refers to the proceedings below and various orders that were made for disclosure and that Mr. Justice Jamadar was actually asked to consider whether or not the Commission had taken account of certain matters, and his view on the documents disclosed were that they hadn't taken account of delay, media publicity, or indeed the Section 137 proceedings. And then on the 7th of February, he gave a oral judgment, which was afterwards confirmed in effect in writing. He said 4 of the charges could not be pursued, those related to the other dates, because they simply hadn't been the subject of investigation and indeed had no causative effect in themselves on the abandonment of the proceedings, and also said that it was unfair that he'd not been invited to give an explanation. It might just be worth looking quite how he put it, because we are going to submit that the reasoning that was exposed there would have been equally applicable to the 2 surviving charges. And if we look at this is bundle 1. This is the official record now. Bundle 1, I think at 5015. Certain whether I have the reference there correct. Can someone lift it on my left? Which page do they say that the 4 charges are not proceeded with because well, 491 here. Just forgive me for... Well, that's at 505.01 where he's dealing with, yes, he's having dealt generally with the question through the perspective of fairness, as distinct, actually, from the perspective of the requirements of the regulations themselves, to which I shall come in due course. What Mr. Justice Jamadar says at page 500 in relation to these 4 other charges was no explanation was sought to with respect to the same. Indeed, neither was the investigating officers or any of the persons who gave written statements attention direct to any such conduct. Yet the claimant now faces charges for which his dismissal from office is being sought with respect to such alleged conduct. In my opinion, the defendant is circumscribed by the principle of fairness as elucidated above. There must, in my opinion, there must be reasonable nexus between the specific allegations investigated for which an explanation and written statements are sought, and the particular act about which is reported on, and we'll come to the regulations shortly, and any charges that may be preferred arising after that consideration of that report. In my opinion, to commit otherwise would be to allow arbitrariness and unfairness to enter into the process intended by Parliament and as provided for in the regulations. So we respectfully submit that the very point that is there made is equally applicable, not just on grounds of fairness, but because the regulations actually require the particular investigation to be that which is, the particular allegation to be that which is investigated, on which a report is made, to which the Commission's mind is directed, in respect of which earlier an explanation will have been sought, and it isn't therefore permissible simply to change the nature of the allegation originally investigated and explained to a different allegation, and then simply bypass the process envisaged by the regulations.
Do you accept the test of some reasonable nexus?
No,
you don't.
I don't. I don't. Well, 517 to 518, he does explain how he suggests that there is, as it were, while he thought that the 4 allegations could not be pursued, why the surviving 2, even in their modified form, could be. He says that at 517. And again, what is interesting is he deals with it in the context of fairness as distinct from in the context of the for the procedure envisaged by the regulations. The two have affinities, but they're not identical.
Presumably, I mean, that's because it wasn't argued.
Well,
In terms of ultra vires.
well, I'll come to that if I may in due course. We don't accept that precisely the way my Lord Mance puts it to me. In my opinion, what he says now, 517, the two charges preferred with respect to the alleged events of the 5th of March 2007 are not in breach of the principles of natural justice or of fairness as identified here and above. In particular, so far as the overriding principle of fairness articulated by Lord Steyne is concerned, even though, now this is interesting, even though the two charges are different from the allegation investigated, when I come to show your Lordship the regulations, we will respectfully say that by itself is fatal to the continued preferment of these charges. In my opinion, he then says, there's a sufficient nexus between the initial allegation, investigating officer report, and the explanation given by the claimant to permit these two charges to stand. And we would respectfully say the regulations don't require a sufficient nexus. They don't require, as it were, proximity between the initial allegation and the final charge. They require identity. That identity is not present, and indeed Mr. Justice Jambadar rightly says it's not present because he's identified them as being, in his epithet, different.
The difference being the note 58 difference.
The
difference being footnote 58, the footnote 58 difference. Is that right?
Yes. Yes. Well, he puts it in a footnote because he's looking at it, as it were, in these broad terms without considering the details of the regulations themselves. In any event, I mean, a difference is a difference. I mean, I suppose it might be arguable that de minimis might not require some adaptation. I mean, supposing, for example, they had been able to pursue the matter, supposing they were able to pursue the matter in relation to what happened earlier on the 5th of March in dialogue between the prosecuting counsel and the chief magistrate, and the amendment was modestly to adjust the timing. That might be thought to be, as it were, de minimis, because that would be relatively insignificant if there'd been, let's say, a series of discussions on that morning. But that isn't this case at all, because it's the Rubicon point. And then he went on, he dismissed the idea that it was oppressive or unfair, and that really his conclusion was you can still have a fair trial. And if you can have a fair trial, notwithstanding all that has transpired, that is of itself sufficient to allow these matters to go ahead. We say, of course, that that's not the only consideration, and in respect not so much of the matters going forward at all, but in respect of whether this would have been one of those unusual cases in which the Chief Magistrate should have had an opportunity to make representations to the Commission to see if he could persuade them why they should not have gone ahead at all. Then there was the appeal to the Privy Council. They decided themselves that the four charges, it was unfair, in fact, to allow them to continue, because in a sense they added nothing, they were duplicative. Can I just again show my lords and my lady what was said? That's in the third volume of the bundle, the official record. Fine. And the judgment is at 1278 through to 1368. And what the Commission said, what the Court of Appeal said there in our submission is that one of the reasons why the four charges should not go ahead was set out at page 1342 to 1347. And we say, again, that if one looks at the reasoning there, we say actually it was equally applicable to the two remaining charges. There are only 3 paragraphs I need to press your lordship, my lady's attention to before the midday adjournment, if I may. One is at paragraph 81 at 1342. The value of the investigatory stage is not to be underrated. It's an extremely important part of the disciplinary process. The investigating officer gathers the facts, documentary evidence, and takes statements. It is, in my view, important to make specific allegations and provide approximate time of commission. One notes the word specific. These are essential prerequisites, and then if one mistakes the material, the rest is just about how the due process is investigation. Then at 84, with no ill intent, now this setting out the letter of the 9th of March, which is the one the Chief Magistrate was invited to address, and indeed which reflected the mandate given to Mr. Justice Venture, with no ill intent, the JLSC chose to lead the appellant down a specific path. If I may borrow an expression from counsel, though it was used in another context. The appellant's ability to make full answer to the allegations of matters occurring on other dates was clearly impeded by the tenor of Jeffrey's letter to Mr. Justice Venture, which specifically referred to the events of the 5th of March of 2007 as the alleged misconduct being investigated. And then finally at 91, 1347, accordingly it seems to me that a gravamen of the charge is the collapse of the case against the Chief Justice. It would not be fair to unnecessarily duplicate the charges to include the events of the 2 earlier days, particularly in light of instructing Mr. Justice Venture to investigate the events of the 5th of March and to communicate to the appellant of the subject matter of the inquiry relating to that date. That does not, in my view, comport with the principle of fundamental fairness. Now, the submission is a very short one. Although I accept that these observations, assented to by all members of the Court of Appeal, were referable to why it was inappropriate to pursue allegations relating to the 2 earlier dates, their reasoning actually should have led to the conclusion that equally they should not allow the continued prosecution of the 2 surviving charges, because the allegations, the specific allegations, were not the same as those in the original letter indicating what was to be investigated. Equally, that letter would have said to lead the appellant down a specific path, that is to say, did you or did you not actually refuse? His ability to defend himself was equally clearly impeded by the tenor of the letter to Mr. Justice Venture and the subject matter of the inquiry in that relation, although it coincided in terms of date, did not coincide in terms of the events that were germane to the original allegation, that's to say, an alleged refusal to give evidence, and the what is now said, which is a prior indication not to do so. If that's a convenient moment, yes, I can then come, as it were, to the submissions, yes, many of which have already been teased up.
Until 2 o'clock.
Peter, you really want to take objection to all of those points?
Sorry?